Welcome to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. And now your hosts, Tim Kowal and Jeff Lewis.
Well, you mentioned about the elevator pitch problem. We talk about a lot as the throwing the spaghetti at the wall problem. When you don't have a theory of the case and you're just going to throw all your arguments out there. And it made me think back to from your time on the bench. Are there some best practices that you can share with our audience about brief writing to grab the court's attention? I take it the same advice would apply there. Don't throw all this spaghetti at the wall. Do a lot of attorneys have trouble learning that lesson?
Well, one thing that I love about attorneys and one thing that annoys me is that they're so thorough that the one thing that an attorney fears more than being buried alive is missing something. So think about the bar exam. It's all about recognizing issues. So that thoroughness leads to overwriting generally and over-arguing generally. When I was on the law and motion bench, I frequently would raise my hand and say, okay, you're running the loop again, and you don't need to do that. I heard the argument the first time. Another thing that I used to say is somebody had told me that I could have written a shorter brief, but I didn't have enough time because it takes more time to write succinctly than it does to write to the point. So not giving up an issue, I think I used to say on the Court of Appeal, there's nothing stronger than conceding an issue. To say, all right, Your Honor, I know that issue is not my strongest point. Let me tell you what my strongest point is.
But that goes against all of our training.
Exactly. And it takes courage. It takes courage to do that because your client doesn't like to hear that, for one thing. You know, your clients pay by the inch for the briefs and they want it to be thorough.
Right.
But
what's the advantage of conceding a point? What does that buy the attorney?
It buys you credibility in the Court of Appeal. To argue a point that's clearly not the most important point, and you've got 15 minutes to make your argument is just a waste of time. And we always noticed when somebody would say, I'm not going to talk about that. I'm going to talk about this. And that's what's strong about it. And it takes the courage of your convictions, knowing what your case is about, and not simply being ultra thorough. I would say too that I will mention one other pet peeve. I suppose it's a pet peeve. Would be the I don't know what you'd call it, the battle theory that I'm not going to answer any of your questions. You're not going to get any cooperation out of me ever on anything. I'm going to fight you tooth and nail right to the courthouse steps in front of the jury. I still run across attorneys that behave that way, and it's always annoyed me, but it's also at counter purposes with what their job is. And I think we've all observed there are a sizable percentage of attorneys who get along pretty well just by being unpleasant. You can settle cases with you can recognize cases that'll settle just because I'm tired of dealing with that guy. So I always encourage people to remember to show not compassion, but allow your opponent to save face. You don't need to grind their heel on the fact that they've lost their motion.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.